I had to get more involved in technical legal discussions than I wanted to as a layman. In the process, my respect for the impressive constructive accomplishments of this discipline has grown even more. My proposals for clarifying the paradigmatic background understanding of the law and the Constitution are intended as a contribution to an ongoing discussion. Specifically, this contribution is directed against the growing skepticism among legal scholars. Above all, against what I consider a false realism that underestimates the empirical impact of the normative presuppositions of existing legal practices. Moreover, a moral practical self-understanding of modernity as a whole is articulated in the controversies we have carried on since the 17th century about the best constitution of the political community. This self-understanding is attested to both by a universalistic moral consciousness and by the liberal design of the constitutional state. Discourse theory attempts to reconstruct this normative self-understanding in a way that resists both scientistic reductions and aesthetic assimilations. The three dimensions of cognitive, evaluative, and normative validity that have been differentiated within the self-understanding of modernity must not be collapsed. After a century that, more than any other, has taught us the horror of existing unreason, the last remains of an essentialist trust in reason have been destroyed. Yet modernity, now aware of its contingencies, depends all the more on a procedural reason, that is, on a reason that puts itself on trial. The critique of reason is its own work. This double meaning, first displayed by Immanuel Kant, is due to the radically anti-Platonic insight that there is neither a higher nor a deeper reality to which we could appeal, we who find ourselves already situated in our linguistically structured forms of life.